we've been talking mostly about patents. Why don't you speak a little bit, Will, to some intellectual property for an academician as it pertains more to copyright and trademark?
Sure. So copyright is nice because you don't have to file something in order to have the copyright. So unlike patent, where it's first to file, or trademark, where if someone else hears your idea and they're in a different geographic location, they may be able to start using that mark. If you publish something, you own a copyright to it and you can enforce rights. That said, if you obtain a copyright registration, and they're pretty cheap to get, it's $50 or $100 to file, and then you have certain access to the courts, certain statutory damages, and there's some advantages there. But the pressure is not on with copyrights the way it is with patents or trademarks or trade secrets.
How does that apply to software, for example?
Yeah, so software is the trickiest. I mean, we treat that as a trade secret a lot of the times, and it's often a complicated question whether you're going to call Shauna or call me, right? Because there is software that is patentable, and there's software that you may opt not to patent. And Shauna, you may be able to speak. I don't know if that's right in your wheelhouse, but that seems like a key gating question that I encounter a lot.
Right. So I am a life sciences attorney, so I don't do much in that space. But a couple of things. So you file a patent application. It takes at least 3 years, if that, to have it issued. So in terms of software, you got to look at the life. Is that, by the time your patent issues and you have your protection, you're on to the next thing. It's obsolete. So sometimes patents aren't the best route for that type of technology. Also, as you guys may be aware, there have been recent Supreme Court decisions calling into question what is patent eligible. For example, laws that are abstract ideas in business methods. These things are being called into question as being laws of nature or abstract ideas, etc. And also the Bilski decisions. These things are saying simply because you add a computer, you really haven't done much to take it out of the realm of being a law of nature. So those are really affecting the patents in that space right now.
This is in my wheelhouse because that's what I do is software development. And so the real thing to pay attention to is the architectural schema of the software. So for instance, when you write code, what the platforms on which the code is built on is more important than the actual lines of code from a copyright standpoint. So you got to be really, really careful about somebody saying, oh, well, we'll just change this basic schema structure and then I can get around your copyright. So the way you write software patents and software copyrights, there's a trick to it, and I can tell you, I've done it well and I've done it poorly, and it's an art unto itself, and we could do an entire session on it. So if anybody's actually interested in that, I mean, I understand code structures relative to how to get it through intellectual property, and it is its own game, just like Will was saying. It is, you have to be really careful. You also have to, when you're doing the code, save it in various iterations based on the way the patent attorneys actually like it to be done for software patents, and make sure that you have iterations of the code along the way that you can prove how you did the structure. Like I said, if anybody's really interested, it's its own entity. I'm more than happy to talk to you about that.
Well, one good thing about software is that you can protect it contractually, and you can use these click-through agreements. And I draft these click-through agreements, so I know how incredibly onerous they are, but people click on them regardless. And EULAs, right. So individual license agreements. So the other night, my wife and I were signing up for care.com, and we got halfway through, and there was a pop-up agreement, and I was checking it out. It was impressively onerous, right? Just to get a babysitter. You're giving up all this rights to your information. My wife said I was a huge nerd for spending the time reading it, but that's an option, right? So if you have software, work with an attorney. You can require users before they ever install it to click through, and then you're protected from the trade secret side.
Yeah, writing the EULAs is important as the non-disclosure. Right. I mean, I'll be honest with you, that one is worth the money to get done well. So if you do software, you can't that's money well spent with an attorney to get the EULA written well.
So I guess one other thing I heard in there was make sure we read everything that was signed
care
and
of
click
it.
off on, right?
Easier said than done.
And
sure.
Ancestry.com. Yeah.
Right.